In our politics lead, the U.S. Supreme Court heard arguments earlier today over a case that pits two competing American principles against one another: free speech and freedom of religion, and the right to not be discriminated against. On one side, whether a graphic designer who holds religious views opposing same-sex marriage should be forced by the government to take customers who want her to make websites promoting same-sex weddings. And the other side, whether LGBTQ couples have a right to receive services from private businesses free of discrimination, just like a straight couple. CNN's Jessica Schneider has more on this fight.
The Supreme Court now poised to decide whether certain businesses can refuse to work with same-sex couples on the basis of free speech.
Granting such a license to discriminate would empower all businesses that offer what they believe to be expressive services, from architects to photographers to consultants, to refuse service to customers because of their disability, sexual orientation, religion, or race.
Colorado web designer Lorie Smith, who openly declares she's selective about website she'll design, brought the case. She's asking the Supreme Court to rule that she does not have to comply with a state law that prohibits businesses from discriminating against same-sex couples.
The state of Colorado is forcing me to create custom, unique artwork, expression, communicating and celebrating a different view of marriage, a view of marriage that goes against my deeply held beliefs.
But the liberal-leaning justices expressed concern that if creators can choose their customers, discrimination could run rampant. Justice Ketanji Brown Jackson asking whether a mall photographer could say only white kids can sit on Santa's lap, and Justice Sonia Sotomayor asking about interracial or physically disabled couples being turned away.
So it doesn't really, there is no line on race, there is no line on disability, ethnicity, none of the protected categories. That's in a public accommodation law.
The First Amendment is broad enough to cover the lesbian website designer and the Catholic calligrapher. The line is that no one on any side of any debate has to be compelled to express a message that violates their core convictions.
Smith says she is in the business of expressive speech, and while she's not opposed to working with same-sex couples in other areas, she argues she should be able to choose the messages she promotes, an argument some conservative justices seem to side with.
So the question isn't who, it's what.
Always.
Why are you right about how you characterize website designers? Why are they different from, say, restaurants?
Because they're creating speech. In those other examples, speech is not at issue.
The Supreme Court sidestepped this same issue 4 years ago, ruling in favor of a Colorado baker who refused to make wedding cakes for same-sex couples, but on very narrow grounds that only applied to that case.
Our rights are not up for debate.
Now the stakes are much higher, with concern building among LGBTQ advocates that a ruling for the website designer could be a harbinger for other adverse rulings.
If there were to be a loophole of the kind discussed, people with disabilities, African Americans, Jews, Muslims, others could find themselves without access to the marketplace.
Now, there's currently no case before the Supreme Court that would eliminate the right to same-sex marriage, but still there is this concern that conservative justices could eventually overturn that precedent. After all, Jake, it was just a few months ago that they overturned Roe v. Wade, and in that opinion, Justice Clarence Thomas said that this court should take a look at overturning other precedents, including the 2015 ruling that did establish same-sex marriage nationwide. Jake?
All right, Jessica Schneider outside the U.S. Supreme Court for us. Thanks so much.